So I know it's not Monday, and you're probably wondering, Liv, why is there a new episode on a Thursday? Well, if you know me, you know I've been following the high profile trial that's happening right now. And of course, I'm asking human behavior questions. The more I thought about it, the more I realized I didn't want to wait until Monday to talk about it. So I figured I'd jump on here, put together a bonus episode, and explore it with you. Before we start, this episode discusses the deaths of children, including a currently active murder trial, along with a suicide attempt. I will keep the details restrained, but if this isn't something that you want to listen to today, that's completely understandable. Take care of yourself, and I will see you in the next episode. In a courtroom in Plymouth, Massachusetts, opening statements have begun in one of the most closely watched trials in the country. Lindsay Clancy, a former labor and delivery nurse, is accused of strangling her three young children in the basement of her home in January of 2023. 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan. She's also accused of attempting to take her own life afterward, cutting her wrists and jumping from a second-story window. Her defense isn't disputing that she did it. They've said so directly in court. What they're disputing is whether she should be held criminally responsible for it, arguing that she was in the grip of a severe postpartum psychosis, compounded by a rapidly shifting cocktail of psychiatric medications at the moment it happened. It's an insanity defense. And by the time the first witness was even sworn in, most of the internet had already reached a verdict. I mean, search her name and you'll find true crime podcasts, comment sections, and hot take videos that had fully made up their minds long before a single piece of evidence was presented in a courtroom. Some landed on a broken, over-medicated woman who needs treatment, not prison. Others have landed on a mother who killed her children doesn't get to hide behind a diagnosis. Full, confident stories built well before the full picture existed. Take the medication question. On the first day of testimony, prosecutors introduced a bag of pill bottles and noted that only a fraction had actually been taken. Presented that way, it read as clear evidence she stopped taking her medications. By the end of cross-examination 2 days later, that picture had changed. Some of those pills weren't ones she'd been skipping. They were prescriptions a doctor had already discontinued, sitting in a bag headed for disposal, which really raises an uncomfortable question for anyone who already picked a side. What exactly was that certainty built on? Today, we're using this trial as our way into a much older pattern. You'll recognize it once we walk through cases like Hinckley and Yates. And it's a pattern playing out again, in real time, in a courtroom, right now. Welcome back to The Human Pattern. I'm Liv. If you're curious about why people think, feel, and behave the way they do, I'd love for you to subscribe or follow the podcast. And if you find yourself leaving an episode with more questions than answers, then you're exactly where I hope you'll be. So subscribe wherever you're listening so you don't miss future conversations. All right, let's get into it. Most of us have a very simple internal rule for judging other people's actions. If you did the harmful thing, you're responsible for the harmful thing. Action equals blame. The insanity defense exists in the one place where that rule breaks down, where the law says a person can commit an act fully, undeniably, and still not be criminally responsible for it. That gap between she did it and she's guilty of it is one of the most psychologically uncomfortable spaces in the entire legal system. And it turns out to be a gap we're extremely uncomfortable leaving open. So uncomfortable that a lot of us fill it in long before a jury ever gets the chance to. Today, we're going into that gap, what the insanity defense actually is, why cases like this one become instant, divided public verdicts before the evidence is even in, and what that reveals about how your brain decides who deserves blame. Here's something psychologists have observed again and again. Humans are wired with an intuitive sense that consequences should be proportional to intent. We don't just ask what happened, we ask, did they mean it? Almost instantly, and mostly without noticing we're doing it. Step on someone's foot by accident and you say sorry. They say it's fine, everyone moves on. Step on someone's foot on purpose, and it's an entirely different interaction, even though physically the exact same thing happened to the exact same foot. This is sometimes described as the just world framework, which is a deep assumption that outcomes should make moral sense, that bad things should happen to people who did bad things on purpose, and that punishment should match the intent behind the act. The insanity defense asks the jury to do something that framework actively resists. It asks them to look at a severe harm, like the deaths of 3 children, and separate that harm from the mental state behind it. And that's not a small ask. It's asking the brain to hold apart 2 things it desperately wants to fuse back together. What happened, and who's to blame for it? Before we go further, it's worth being precise because the public idea of insanity defense and the legal one are just not the same thing. Legally, most crimes require 2 things to be proven. First, that a person committed the act, and that's called actus reus. Second, that they had the required mental state to be held criminally responsible for it, and that's called mens rea. The insanity defense doesn't dispute the act, it disputes the mental state. It argues that at the moment of the act, the person's mental condition was severe enough that they either didn't understand what they were doing or didn't understand that it was wrong. The most widely referenced standard is the M'Naghten Rule from an 1843 British case. In simplest form, it asks, did the defendant, because of a mental disease, not know the nature of the act or not know that it was wrong? Some jurisdictions use a broader standard that also asks whether the person could control their behavior, not just understand it. And here's the detail most people get wrong. The insanity defense is raised in less than 1% of felony cases, and it succeeds in only a fraction of those. It's not a common outcome, and it's not the loophole it's often portrayed as. It's also not the same as walking free. A successful insanity defense typically means commitment to a psychiatric facility, often for a period that can equal or even exceed a prison sentence, because release depends on a court being convinced the person is no longer a danger, not on a fixed date. The legal question was never, did this person do something terrible? It's always, can we hold this specific mind responsible for it in the way the law defines responsibility? And if you're noticing this feels uncomfortable, that's the point. The law is asking us to separate 2 ideas our brains instinctively fuse together. And here's the question underneath all of this, the one the public argues about far more than the legal standard itself. How does anyone actually tell the difference between someone who was cold and calculated and someone who was genuinely severely mentally ill? The honest answer is uncomfortable. Nobody can climb inside another person's head at that exact moment of the crime. Not a jury, not a judge, not even the psychiatrists who spend hours with the defendant. What forensic evaluators are doing in every one of these cases is reconstructing a mental state that's already gone, sometimes months later, sometimes years later, using only what got left behind. That reconstruction draws on a specific set of evidence. Records from before the crime, so psychiatric history, hospitalizations, medication changes, any documented delusions or hallucinations reported to doctors before anything happened, behavior during the act itself, pieced together from witnesses, 911 calls, physical evidence, and behavior immediately after, which turns out to carry more weight than people expect. Did the person try to flee or hide the body or lie to investigators? Or did they call for help themselves, stay at the scene, or attempt suicide? Evaluators read those choices as data points about whether the person understood in the moment that something wrong had happened. It's not a perfect signal. A psychotic break can also produce confusion, dissociation, or delusional logic that makes someone call 911 for reasons that have nothing to do with recognizing wrongdoing. But it's still one of the few pieces of behavior that happened close enough to the act to matter. And then evaluators look for internal coherence. This is the part that trips up a lot of the public intuition. We tend to assume calculated and psychotic are opposites, that planning proves sanity and confusion proves illness. Forensic psychiatry doesn't work that way because psychosis can actually be highly organized. A person in the grip of a genuine delusion can wait for the right moment, plan carefully, and execute a sequence of steps, not despite their illness, but because of it. The planning isn't evidence they were faking or clear headed. It's evidence of how convinced they were that the delusion was real. What evaluators actually weigh isn't whether the act was organized, it's whether the reasoning behind it, however organized, was internally consistent with a documented severe mental illness, or whether it tracks with an ordinary, comprehensible motive like jealousy, revenge, or financial gain. And because a defendant has an obvious incentive to appear more impaired than they are, evaluators also have to screen for exaggeration or outright faking, using structured tools designed to catch inconsistent or implausible symptom patterns. This cuts both ways, too. It's just as possible for a genuinely psychotic person to underreport their symptoms out of shame, fear, or the illness itself distorting their sense of what's worth mentioning. This is also why these cases so often come down to dueling experts. The prosecution hires a forensic evaluator, the defense hires another. Both review largely the same records, and they frequently reach different conclusions. That's not evidence that one side is lying. It's evidence that it isn't a clean binary measurement. It's clinical judgment applied to a legal standard on a question that no test can answer with certainty. The jury doesn't get a diagnosis with a number attached to it. They get two credentialed experts disagreeing and have to decide which account fits the evidence better. The takeaway isn't that the system can't tell the difference at all. It's that the difference was never going to be as clean as cold and calculated versus clearly insane. Most real cases live in the uncomfortable middle. A person capable of planning, capable of concealment, capable of ordinary looking behavior, who was also, underneath it, experiencing something a healthy mind never would. Sorting that out isn't a formula, it's a judgment call made by fallible people about the most private thing there is. In 1981, John Hinckley Jr. shot President Reagan outside a Washington hotel. There was no question about who did it. It was literally captured on camera. The defense argued successfully that Hinckley's mental illness met the legal standard for insanity. The jury agreed. The public reaction wasn't really a reaction to the psychiatric testimony most people never read. It was a reaction to the gap between what everyone had watched happen and the words "not guilty" attached to it. That gap was actually wide enough to change federal law. Within 2 years, Congress passed the Insanity Defense Reform Act of 1984, tightening the standard and shifting the burden of proof onto the defense. Notice what actually moved. Not new science, not a reassessment of Hinckley's diagnosis, public discomfort with a verdict. Discomfort strong enough to reshape the law in under 2 years. We're about to look at two cases built on this same diagnosis. Andrea Yates and the Clancy trial unfolding right now. So it's worth pausing to define it precisely because postpartum depression and postpartum psychosis get used almost interchangeably in everyday conversation, and they are not close to the same thing. Postpartum psychosis is rare. Most estimates put it around 1 to 2 cases per 1,000 births, and it tends to arrive fast, whereas postpartum depression typically builds gradually over weeks. Psychosis usually emerges suddenly, often within the first 2 to 4 weeks after birth, and sometimes within days. The symptoms aren't just low mood or exhaustion, they're a genuine break from reality. Hallucinations, delusions, severe confusion about time and place, rapid and extreme mood swings, and often a level of sleep deprivation that both worsens the psychosis and is worsened by it. Clinically, it's treated as a psychiatric emergency, carrying a real risk of both suicide and harm to the infant, which is why the standard of care is immediate hospitalization, not outpatient management. Here's a detail that surprises a lot of people, and it matters for how you interpret almost anything you see or read about a case like this. Psychosis isn't a constant, unbroken state. It fluctuates, sometimes within the same day. A person can be visibly present, responsive, and even smiling in a photo and still be experiencing genuine psychotic symptoms that simply aren't dominating that exact moment. So, a picture of someone at a playground with their kids or a video of them functioning normally at a grocery store doesn't settle the question of what was happening in their mind. It just tells you what one frozen moment looks like from the outside. That's worth holding on to because, but she seemed fine, is one of the most common and least reliable arguments people make in cases like this. So, does it take prior mental illnesses into account? It does and it doesn't, in a way that matters a lot for how these cases get argued. A personal or family history of bipolar disorder is the single strongest known risk factor for postpartum psychosis. And evaluators absolutely weigh that history when it exists. But postpartum psychosis can also be a person's first psychotic episode, full stop, with no psychiatric history before it at all. That's part of what makes it distinct from most other psychotic illnesses, which usually build over years with a documented trajectory. Picture a woman with no prior diagnosis, no prior hospitalization, no family history of it, someone who, by every account, was functioning normally before pregnancy. She can still develop a genuine severe psychosis triggered by childbirth itself, which means the absence of a prior mental illness diagnosis doesn't tell you nearly as much as people assume it does. And that raises the harder question: what happens when someone doesn't report their symptoms? This turns out to be two different things wearing the same face. One is concealment, a person recognizing something is wrong and hiding it anyway, out of shame, out of fear of being seen as an unfit mother, out of a very real fear that disclosing intrusive thoughts to a doctor could mean losing custody of her children or being involuntarily hospitalized. The other is something psychiatry calls impaired insight, a documented feature of psychosis where the illness itself distorts a person's ability to recognize that anything is wrong. In that version, someone isn't hiding symptoms. They genuinely don't experience them as symptoms. From the outside, those two things can look identical. A mother telling her doctor she's fine when she isn't. But they point to opposite conclusions about what was happening in her mind. And untangling which one applies to a specific person at a specific moment, using only what got said and unsaid months or years earlier, is exactly the kind of retrospective judgment call we talked about back when we talked about how forensic evaluators actually do this work. I want to name something here honestly, rather than gloss over it. Everything we just covered is literally the surface of a much deeper subject. Postpartum psychosis sits inside a much bigger, still evolving conversation about how dramatically hormonal shifts can affect mental health, not just after childbirth, but across puberty, menstrual cycles, pregnancy itself, and menopause. Researchers are still working out exactly how estrogen and progesterone interact with the brain chemistry behind mood and psychosis. And it's a field that, frankly, has been understudied relative to how many people it affects. That's a genuinely fascinating, complicated topic, and it really deserves more than a few paragraphs inside someone else's episode. So I'll say this directly. Would a deep dive into the relationship between hormones and mental health be something that you'd want to hear? Think PMDD, perinatal mood disorders, perimenopause, all of it. If that's a real interest, let me know. Reach out through the comments, and there's links in the show notes. That's an episode that I genuinely love to build. In 2001, Andrea Yates drowned her 5 children in Houston. She had a documented history of severe postpartum psychosis, multiple hospitalizations, and prior suicide attempts. Expert testimony described a woman who, in psychosis, believed she was saving her children from damnation. Her first trial ended in conviction, partly on the strength of testimony later found to be factually false, and the conviction was overturned. At her second trial, with a more complete psychiatric context in front of them, jurors found her not guilty by reason of insanity. Same outcome as Hinckley, but a very different public reception. Less outrage, more reluctant acceptance. What changed wasn't the underlying illness, it was how much of the full picture the public and the jury had access to before forming an opinion. Which brings us back to Clancy and to why everything we just walked through isn't just historical. Her attorney has said in court filings that she'd been prescribed more than a dozen different medications in the months before the killings, and argues that that regimen contributed to psychosis and homicidal ideation. Prosecutors, in their opening statement, pointed to a different story, that she didn't stay consistent with treatment, and that toxicology suggests she hadn't been taking several of those medications as reported. Both of those things can be true at once, and figuring out how they fit together is exactly what this trial exists to do. That's the part that's easy to lose in a comment section. A jury is being asked to sit with genuinely conflicting, incomplete information and reason through it carefully, in public, under oath, which is a much harder and slower process than reading a headline and reacting to it. You can already see the planning versus illness framework from a moment ago playing out directly in the opening statements. Prosecutors have pointed to the fact that Clancy sent her husband out of the house before the killings, which they've characterized as a deliberate choice made with clear intent. The defense doesn't dispute that she did it, but argues it has to be understood inside the psychosis they say she was experiencing, not as proof she was thinking clearly. That's precisely the distinction forensic evaluators are trained to sit with. An organized sequence of actions doesn't settle the question on its own. What matters, legally, is the reasoning underneath it. And that's what the jury will spend weeks hearing dueling experts argue about. Before the trial began, most of what circulated publicly about the case came from secondhand accounts, a widely discussed magazine profile, true crime podcasts working from what was available, online debate built on partial information. Some of that coverage was thoughtful and very well researched, but well researched from what's public and complete are two different things. And a lot of the internet's certainty was built on the first while assuming it had the second. Now, in the courtroom, more details are surfacing that weren't part of the public record before. Testimony from her ex husband has revealed that months before the killings, Clancy went to an emergency room after going roughly 48 hours without sleep, and prosecutors say hadn't disclosed to the hospital staff that she had taken a marijuana edible that day. It's worth pausing here on something bigger than any one detail. Why testimony can shift so much between one side asking the questions and the other. A witness on direct examination, being questioned by the side that called them, can only answer the specific question they're asked. They can't volunteer extra context. And if they try, the other attorney can object and have it struck from the record before the jury ever really hears it. Attorneys know this, and they build their questions deliberately, often narrowly, to guide a jury towards exactly the point they want to make, one contained answer at a time. Cross-examination exists specifically to counter that. It's the other side's chance to ask the follow-up questions that direct examination was never going to ask. The ones that might complicate or outright correct the impression the first round of questions left behind. That's exactly what happened with the medication detail from the top of this episode. The pill count sounded like one thing under direct examination, right? It meant something more complicated once cross-examination filled in what direct examination had left out, which means a full, accurate picture of what a witness actually knows often doesn't exist until both sides have had their turn, not just the side that called them to the stand first. Notice how directly this connects to the underreporting question from a moment ago. Was the marijuana detail a concealment, a choice to keep something private, or was it impaired insight, a mind already struggling to accurately track and report its own state? The prosecution and defense are going to tell two very different stories about that exact same set of facts, and neither story is unreasonable on its face. And that's what makes this hard. And it's exactly why it's going to a trial instead of being settled by anyone reading a headline or listening to one side's questions and stopping there. Whichever way this trial ends, it's already demonstrating something important. A lot of what looked like a complete story wasn't one. It was the best story available at that specific moment in testimony, mistaken for the whole picture. There's one more detail from testimony worth naming, because it's almost a live demonstration of the dueling experts problem. Part of the defense's account involves what's clinically called a command hallucination, a voice Clancy said she had heard. Prosecutors are working to raise doubt about that account, questioning its timing and origin. The defense maintains it wasn't something manufactured for the case. Neither side can hand the jury a scan or a test that settles it. That's not a flaw in this particular trial. It's the same unresolved question we walked through earlier, playing out in real time, with 3 lives at the center of it instead of a hypothetical. Your brain has a documented discomfort with unfinished stories. Give the brain a gap and it doesn't wait patiently. It starts writing an ending. An active criminal case is a gap by design. Investigators, prosecutors, and defense attorneys withhold information deliberately and for good reason, to protect an ongoing investigation, to avoid tainting a jury pool, to keep a trial fair for both sides. Grand jury materials are sealed. Some evidence is inadmissible. Attorneys are bound by rules about what they can say publicly before a verdict. None of that is a cover-up. It's how the system tries to make sure a verdict is built on evidence a jury actually examined, not on whatever version of the story got the most engagement online in the meantime. But the public doesn't experience a news vacuum as wait and see. It experiences it as a gap to be filled. And true crime media, well intentioned or not, often ends up filling it. A well produced podcast can walk through the available facts carefully and responsibly and still end up handing listeners something that feels like a finished story. Because a satisfying narrative arc is what the format rewards. The gaps get smoothed over. The uncertainty gets resolved into a conclusion because we don't fully know yet doesn't make for a great final episode. And that's not a criticism of curiosity. It's just worth naming. The confidence a story produces and the completeness of the facts behind it are not the same thing. You can walk away from an excellent, well researched 2-part podcast series feeling certain about a diagnosis, about a system's failure, about a verdict that hasn't happened yet, and still be filling in gaps the people actually holding the evidence haven't closed. Here's the part that's easy to miss. It's tempting to imagine the courtroom as a place where all of this brain wiring gets set aside, where evidence and law replace gut reaction with something cleaner and more objective. But it doesn't work that way because there's no version of a justice system that isn't run by people. The jurors deciding Clancy's case are subject to the exact same just world intuitions we talked about earlier, the deep pull to make punishment match harm. The attorneys building each side's story are doing the same narrative construction your brain does with an unanswered text message, just with more evidence and higher stakes. Even the standard itself, McNaughton, written back in 1843, was written by people trying to translate a psychological question into a legal one. And it shows the limits of that translation every time a case like this one tests it. That's not a flaw unique to this trial or a reason to distrust the process. It's just the honest starting point. There is no perfect justice system because a justice system is made of the same minds that build stories out of silence, assign blame based on a gut read in a half a second, and want more than almost anything else for an unfinished story to resolve. The system's whole design exists specifically to slow that instinct down, not to eliminate it. The rules of evidence, sequestered juries, appeals, the slow and frustrating pace of an actual trial, all of it. It can't be eliminated. It's just how humans running the system are built. So, why does a case like this get decided by so many people before the trial even starts? I don't think it's because people don't care about getting it right. I think it's because the brain's blame system evolved to answer a faster, simpler question than the one a courtroom is built to ask. For most of human history, the useful question wasn't, what was this person's precise internal mental state? It was, is this person dangerous and should we protect ourselves? Fast, binary, survival focused. A trial is trying to do something slower and more precise. Separate the act from the mind that produced it, using only what's actually been proven, not what feels true. Those two systems, the ancient one and the legal one, aren't always going to move at the same speed. And the friction between them isn't a sign that something's broken. It's a sign the legal process is doing something evolution never asked our brains to do. Maybe the real pattern isn't about insanity or even this trial. It's that we keep expecting certainty from a process that's specifically designed to be slow, incomplete feeling, and uncomfortable right up until the end, because that discomfort is actually what keeps a verdict honest. This week, notice the next time you feel fully certain about a story you only know part of, a trial in the news, a headline about someone you've never met, even a conflict between two people you know. Before you settle on a verdict, I want you to ask yourself 3 questions. What do I actually know? And where did I learn it? What am I filling in myself just because it makes the story feel complete? And if the honest answer is, I don't know yet, can you actually say that out loud and let it sit there instead of reaching for an ending? You don't owe anyone a finished opinion on an unfinished story. Try swapping your certainty for something more honest, based on what's actually been established so far. That sentence costs you nothing, and it leaves room for the rest of the story to arrive. The Clancy trial is still unfolding as this episode goes out, and it deserves to be watched carefully, not raced to a conclusion, whatever that conclusion ends up being. That's not indifference to what happened to Cora, Dawson, and Callan. It's the opposite of indifference. It's taking it seriously that getting this right matters more than getting it fast. If this episode changed how you're thinking about a story you've already decided you understand, I would love to hear about it. Feel free to drop in a comment, and there are links in the show notes to all of my socials and my website. And one last thing. This episode touched on suicide and severe mental health crises. If you or someone you know is struggling, You can call or text 988 anytime to reach the Suicide and Crisis Lifeline. Free, confidential, available around the clock. That's 988. Don't forget to subscribe wherever you're listening, and if you're enjoying The Human Pattern, a rating or a review helps more people find the show. Until next time, stay curious, question the pattern, and I'll see you in the next episode.